Thank you very much, Sean, and welcome everybody. Thank you for joining us today for Commercializing Cannabis in the Face of Regulatory Uncertainty. I am very pleased to have two of my colleagues presenting with me today. Sativa Rasmussen from our Seattle office has a practice that's centered around regulatory compliance and corporate matters, specifically in the hemp and marijuana industries. And has many years of experience and has really grown up along with the industry and knows the ins and outs of the regulation of the practice. And Sativa is going to tell you more about that in just a moment. And Joe Lynyak, who's a colleague of mine in the D.C. office, although he's greeting us today from Los Angeles, is one of the leading banking and financial industry regulatory lawyers in the country. He has extensive experience in all kinds of financial regulatory matters, and in particular, one of the interesting things about Joe's practice is his expertise in applying federal laws, and particularly federal financial laws, to the cannabis industry. You'll be hearing from Joe a little bit later. So with that, Sativa, why don't I turn it over to you to begin sharing with us the matters of state regulation and licensing.
Yeah, so thank you for the introduction, Chip. I appreciate that. And thank you all for joining us today. Very excited to get going. So I'm going to kick the webinar off today by talking about the current state of play for the industry and how that is evolving. And because we have attendees with varying levels of experience and knowledge in the industry, I thought it might be helpful to begin by defining some key terms that we often see, starting with cannabis. So, sorry guys, this is not changing there we go. So starting with cannabis. Technically speaking, cannabis is a genus of plant within the Cannabaceae family, and cannabis includes multiple different species, including Cannabis sativa L, Cannabis indica, and Cannabis ruderalis. And so when you think of the word cannabis, it's actually an umbrella term that encompasses both marijuana and hemp, though in today's industry, it is often used as almost a synonym for marijuana and is often used in contrast to hemp. So bear in mind that kind of usage as we proceed today. So turning to marijuana, marijuana is a Schedule I narcotic under the Controlled Substances Act. Which means that there is no currently accepted medical use and it has a high potential for abuse. And within the definition in the CSA, marijuana is defined as Cannabis sativa L as well as all of the compounds. And I didn't want to lay out the full definition here because it relates very closely to hemp. Which is our next term. So hemp is defined now within the 2018 Farm Bill, and following the passage of the 2018 Farm Bill, hemp has been explicitly carved out of the definition of marijuana under the Controlled Substances Act. And so what I've done here is set forth the definition of hemp, which is Cannabis sativa L and any part of that plant, including the seeds, all derivatives, extracts, cannabinoids, etc., whether growing or not, with a delta-9 tetrahydrocannabinol concentration of not more than 0.3% on a dry weight basis. And that THC concentration is very important because, as it was mentioned earlier, marijuana and hemp are derived from the same plant. It is really this concentration of THC, which is the compound within the cannabis plant that is responsible for psychoactive effects, And the concentration of THC is what differentiates hemp from marijuana. So THC is what is known as a cannabinoid, and you'll hear this term a lot. Cannabinoids are naturally occurring chemical compounds that are found within the cannabis plant. And these compounds interact with receptors in our body's endocannabinoid system. And despite the fact that there are actually over 60 known cannabinoids, there are definitely a couple that are more well known than others, chief among them being THC as well as CBD. These are undoubtedly the two most well-known cannabinoids that you hear about within the industry. And it's important to note, as discussed a moment ago, both of these cannabinoids can be found in both marijuana and hemp. So one thing to note as well is that CBD, unlike THC, has no psychoactive effect. And this is key in determining whether or not the plant will be hemp or marijuana. So let's turn to the current status of marijuana specifically within the United States. As you can see by the map here, we have currently 11 states plus the District of Columbia that have passed some form of law to allow for recreational or adult use programs for marijuana. And you can see that these states, the West Coast, every state on the West Coast here has a recreational program in place, but there are also states now, we've seen the progression has moved far east as well, and the recreational programs within the U.S. really do span across the country. And in terms of the medical market, we have 33 states that have medical programs in place. And that number also includes those states that have recreational programs as well, because for each state that has a recreational program, it also has a medical program. So what has COVID-19 done to this industry? How is COVID-19 impacting these businesses? This is a question we get very often in today's, kind of state of the world. And it's very interesting to see that of those states that have recreational programs in place, almost every single one, all but two, have elected to designate recreational marijuana businesses as essential and permit them to remain open during the state's stay-at-home orders that are currently in place. And so as of today, there are 9 states that have made this determination, though both Nevada and actually it's just Nevada that has updated their rules to say we will allow for recreational marijuana businesses to remain open, but we are only now permitting delivery. We're not allowing people to come into these retail locations. And for those 2 states that have determined that these businesses are not essential, that would be Massachusetts and Vermont, though those states have elected to continue their medical programs. And interestingly, it's also worth noting that there isn't a single state that has an existing medical marijuana program in place that has issued a stay-at-home order of some kind that has prohibited these medical marijuana businesses from serving patients. Every state has allowed them to remain open. And some of those states have also, similar to what we're seeing in the recreational side of things, where states are issuing emergency rules to allow for things now like curbside pickup and delivery. On the medical side of things, we're seeing emergency rules to allow for physicians to prescribe medical marijuana via telehealth, and each of these states are really kind of adapting to the new status of their individual stay-at-home orders within the state.
Hey, Sativa, if I could jump in for just a second here, just
yeah.
to remind everyone that we do have a chat box, and you can send in your questions if you have. And I was remiss in mentioning that earlier as Sativa goes through this. If you have questions, and the others as well, just send in a text, and we'll try to get your questions answered. Sorry about that, Sativa.
No, absolutely. That's a good point. I'm kind of going through some of these things quickly just because I'm going to lay the groundwork here. So, yeah, as I was mentioned, if you have any questions on anything, just feel free to type those in as I go along, and we'll make sure we get to them. So switching gears now to hemp and the current status of hemp within the United States. To really understand where we are today, it's important to look back just a few years to talk about what is commonly known today as the 2014 Farm Bill. Its technical name is the Agricultural Act of 2014. And this was really the first key piece of legislation in recent years anyways, that relates to hemp and the cultivation of hemp within the United States. And under the 2014 Farm Bill, state departments of agriculture and institutions of higher education were permitted to develop pilot programs to research industrial hemp. And though the language was limited to research, many states interpreted this research to also encompass research related to commercial activities. And so what we saw was the development of state hemp programs for the cultivation, processing, and sale of hemp and hemp products being developed under the 2014 Farm Bill. But just as important as what it did do, it is important to note what it did not do. So the 2014 Farm Bill did not remove hemp from the Controlled Substances Act, and it did not give any federal agency regulatory authority over hemp. But skip to 4 years later, and we had the passage of what is commonly known as the 2018 Farm Bill, which, as we talked about a bit ago, explicitly removed hemp as well as its byproducts from the definition of marijuana within the CSA. And it explicitly broadens the pilot programs that were permissible under the 2014 Farm Bill to include non-academic cultivation of hemp. And the 2018 Farm Bill, it directed the U.S. Department of Agriculture to issue regulations and guidance for the purpose of implementing a program for commercial production of hemp within the United States. And what this piece of legislation did is it set forth the requirement that all states and tribal plans that are developed pursuant to this bill be submitted to the USDA for review and approval by the agency. And it also required that the USDA establish a plan to monitor and regulate the production of hemp in those states or tribes that didn't have an approved plan of their own. And one of the other key things was it afforded protections for the interstate transportation of hemp and hemp products that did not previously exist under the 2014 Farm Bill. So following the passage of the 2018 Farm Bill in December, we had the USDA's publication of the interim final rule in October of 2019. And what the IFR did was outline provisions for the USDA to approve plans that are submitted by the states and Indian tribes for the production of hemp. It gave them a 60-day timeline from the time such plan is submitted until it needed to be approved. And it set forth requirements for testing, destruction of products, violations, potential punishments for violations, things of that nature. And following the publication of the IFR, we had what is referred to as a notice and comment period, whereby the USDA really was seeking guidance from industry participants regarding the various different requirements that had been set forth in the IFR. They wanted to know what cultivators and what processors thought about these regulations, and if they really believed they were going to be setting the industry up for success. And what we saw very quickly was that industry participants did not like several of the provisions within the IFR. There was this kind of outcry from the industry saying, hey, look, these rules are setting us up for failure. There needs to be some changes prior to the publication of the final rule. We had individual participants as well as state departments of agriculture who were sending letters to the USDA to that effect. And following the receipt of so many letters stating these things in October, we had a enforcement discretion update, as they called it, issued by the USDA, whereby the USDA said, we recognize that there is great concern within the industry, and so what we're going to do is delay enforcement of a couple of provisions within the IFR and some of the requirements. Specifically, the requirement that hemp cultivated pursuant to a plan be tested at a DEA-registered lab. So as of today, there are less than 50 of these labs within the United States, which this requirement would have undoubtedly created a backlog and a bottleneck for industry participants. So the USDA took that advice, took the guidance they had received, and said, we're going to delay that enforcement of that provision. And the second provision was the disposal of non-compliant hemp, which under the IFR similarly required disposal by a registered DEA reverse distributor or a law enforcement officer. And the USDA backed up on that and said, we're going to delay enforcement on this as well until the final rule is published, or October 31st of 2021, whichever comes first. So much like the previous map, this map shows the hemp programs within the United States. And as you can see, there are any kind. And those states are Idaho, South Dakota, and Mississippi. So as of last week, when I put this slide together, the USDA had approved 16 state programs that had been submitted under the new interim final rule, and they had 4 additional plans that were being reviewed. And they had approved 20 tribal plans with 13 others that were currently under review. But in addition to those plans that have been submitted pursuant to the IFR, we also have 18 states that have elected to continue operating under their previously existing 2014 pilot programs for the 2020 harvest season. So when the 2018 Farm Bill was published, it had some language that allowed for the extension of the 2014 Farm Bill, and it allowed states to elect to submit a plan under the new rules or continue operating under their existing plan through the end of the 2020 harvest season, so October 31st of this harvest season. And we had a great number of states that chose to do that, just primarily because the restrictions that were in place under the 2014 Farm Bill were far fewer than those under the 2018 Farm Bill. And I think that the hope for most of those states was that there would be potentially a change to the IFR and the rules prior to publication of the final rule. So what does this mean for hemp and hemp products? We know that they're permissible. We know that hemp is now allowable. You can grow it. It's not a controlled substance. But what is often a source of confusion for many is how the 2018 Farm Bill relates to the FDA and the Food, Drug, and Cosmetic Act. And it's important to note that the 2018 Farm Bill and the Interim Final Rule have no bearing on the Federal Food, Drug, and Cosmetic Act. The Farm Bill explicitly preserves the FDA's authority to regulate products containing cannabis or cannabis-derived compounds under the FDCA. So that includes food, dietary supplements, drugs, as well as cosmetics. And to date, there are only 3 hemp-derived ingredients that have been generally recognized as safe as food ingredients by the FDA. And those ingredients are whole hemp seed protein powder, and hemp seed oil. And you might notice that the common denominator between those 3 items is that they are all derived from hemp seed. And the reason that this is important, as Chip will talk about here in a moment, is that hemp seed contains only negligible amounts of CBD and THC. It's almost not even detectable. So aside from those 3 ingredients that are generally recognized as safe, the Food and Drug Administration's stated policy on CBD is that it is illegal to market CBD by adding it to a food or labeling it as a dietary supplement. Note that that statement has no reference to cosmetics. It refers to food or dietary supplements. And so certain cosmetic ingredients are prohibited by restriction, but that's not the case for cannabis or cannabis-derived ingredients. Despite this position, we also have several states that have passed legislation to allow for the use of CBD in food products within those states, chief among them being Colorado, Florida, Oregon, and Texas. We, of course, also have states who have taken the exact opposite approach, which is to state explicitly that their position is such products will not be permissible within the state unless and until there is a change at the FDA on the use of these products in food. We also have a few states that have passed laws to allow for hemp and hemp-derived CBD that is grown pursuant to a validly issued state hemp license to be brought into the recreational marijuana market. And states that allow for that include both Oregon and Washington. So next up, we are going to talk about all of these things and how these rules and regulations are now impacting what we are seeing in terms of enforcement and litigation on CBD and CBD products. And so with that, I will turn it over to Chip to talk about those issues.
Thank you very much, Sativa. And Sativa did a great job of setting the table in terms of the regulatory environment, explaining that you have the 3 hemp seed products that are approved for use, and then you have this kind of uncertain area in which some states have said that CBD products can be sold within the state as parts of food. And on the national level, the FDA says you can't. And so that's creating kind of a complex environment for everyone. Not too long ago, I went into a store back before we all had to engage in social distancing to buy a sandwich, and I looked to my left, and there was a refrigerated case which previously had all kinds of sodas and some juices and the rest. And it was almost entirely filled with various juice products that advertised that they contained CBD. And technically, all those products are illegal since they were not just locally produced and they were sold into interstate commerce. But we get into questions of what's going to be enforced and what isn't. And as many of the people on this webinar know, there is a huge potential market for both beverages and food products that contain CBD. The question is, can you enter that market? Are you going to get a warning letter from the FDA? Are you going to get sued by someone? And we're going to walk through that a little bit. So to expand on what Sativa explained, the FDA's approach to CBD is based on the definitions of a number of terms having to do with food and drugs. And I'm not going to read these to you. You can read them at your leisure. But a drug is, as the FDA sees it, and as Congress has described it, is exactly what you think it is. It's something that's for the use in the diagnosis, cure, et cetera, prevention of disease, or intended to affect the structure of any function of the body. And a new drug, which also becomes an important definition, is one that is not generally recognized by relevant experts who are expert in evaluating the safety and effectiveness of drugs as safe and effective for use under the conditions prescribed or recommended. So we continue on with our definitions, and federal law is very clear that you cannot introduce into interstate commerce any new drug unless you file a new drug application, and which means that the FDA has a potential lever, as do private litigants. We'll talk about that in a moment. If a product touts itself as containing CBD and says, because of this, you're going to reduce your risk of a heart attack, you're going to protect yourself against hepatitis, you're going to, in some cases, they've been promoted as protecting you from COVID-19. If the CBD is promoted as having a health effect or having some effect on the human body and its functioning, it is considered to be a new drug in this context, and the FDA says, you can't do that under federal law. So that's the new drug aspect of it. The FDA has another angle, and that is a misbranded drug. And so these statutes are generally for drugs that have a legitimate and well-understood purpose, but are sometimes used for off-label purposes or used in ways other than intended. And federal law describes a drug as being misbranded, and there are several ways a drug can be misbranded, but as is applicable here, it's if the labeling does not bear adequate directions for use, which the regulations described as meaning that a layman following those directions can use a drug safely and for the purposes for which it's intended. And so the FDA's position is if you are asking the user to self-diagnose and treat a condition and you are not medically trained, those directions are per se inadequate, and you have misbranded your drug. So again, if you have a cream, if you have a food, anything that promotes certain health effects, and you at this point don't have the FDA's approval, which none of them does, with one exception, a particular drug for epilepsy called Epidiolex, you are misbranding your product by touting the benefits of CBD. And then there's the use in food. So if you add something that you introduced into interstate commerce, and I think there's a typo here, but it's a drug that well, actually it's not. There are two ways that you can violate 21 U.S.C. 331LL, which is if you include in food an approved drug. So if you were to take a prescription drug and make it an ingredient of cornflakes, that would be a prohibited act. Or if there's a drug that is undergoing clinical investigations, it's not yet approved, but there are publicly known clinical investigations. If you include that in your cornflakes, it's also a prohibited act. So as I mentioned earlier, CBD is the active ingredient in Epidiolex, which is an approved drug, which means that including CBD in a food is by definition a prohibited act. Similarly, there are several clinical investigations of CBD that are underway, which likewise makes adding CBD to food a prohibited act. So the FDA, under the regs and under statutes, considers such foods to be adulterated. And then, as you can see here, there are similar statutes that have to do with food additives. I'm not going to go through it all, but again, the FDA considers adding something like CBD, even if it isn't considered a drug, if it hasn't been recognized by experts in the area as safe, and there's much debate about that at the moment, you can't do it, and it means that the food additive is adulterated. So the FDA can give you a hard time for having a food or beverage that contains CBD if you're, by that very fact, you have an additive or an ingredient that has not been determined to be safe in the FDA's eyes, and it's deemed to be adulterated. And finally, just the regulation, or rather the statute on dietary supplements, for the same reasons as we talked about with adulteration, if it has a new drug or an ingredient that is currently the subject of publicly announced clinical investigations, it can't be a dietary supplement. So that means that because of its use in Epidiolex and the ongoing clinical investigation of CBD generally, CBD-containing products cannot be considered dietary supplements. Congress currently is contemplating legislation that would change this, but at the moment, that's the way the world works. So what does this have to do with FDA enforcement? The FDA has taken notice of CBD-containing products. It has issued a number of warning letters. Warning letters are technically informal advisory letters that come from the FDA specifically to the company that's marketing the product. They are made public, and the FDA goes out of its way to publicize its efforts. So these often get picked up in the media. And although they do not represent final FDA action, it is not a determination by any judicial body, obviously, that the product is violating federal law. It states the FDA's informal position on the matter. And the reason that I mentioned here that it is technically not a final FDA action and it's informal advisory, when we talk in a moment about lawsuits being brought by private parties, one of the avenues that private litigants are using is to say that if the FDA, through a warning letter, determines that a product violates federal law, that the product is therefore illegally sold, is in violation of the law, and has no value, and therefore, particularly in a class action, every purchaser of the product is entitled to refund of the entire purchase price as damages. That is being challenged in some current litigation on the grounds that it is not a determination that federal law has been violated. It's merely the FDA's opinion on this. Warning letters themselves don't have any effective law, but the FDA can back that up with enforcement actions, and as you see here, in certain cases, that can lead to fines and imprisonment both for the corporation and for individuals. So that is a place people don't want to go. Now, although we've talked extensively about the laws and regulations that lead the FDA to conclude that promoting medicinal use of CBD or including CBD in any kind of food or beverage product violates federal law, the FDA is not going to come running after anyone who does that. As a matter of fact, Commissioner Hahn made a statement, it's quoted here, that the FDA is currently trying to figure out a regulatory framework for CBD. They haven't figured it out yet, but they clearly don't have the resources or the inclination to chase down all these products. And in fact, right now, it's kind of all COVID-19 all the time at the FDA, and they're just stretched too thin. The warning letters that have been issued to date have largely focused on products that either advertise on their labeling or on their social media are advertising treatments for various medical conditions that haven't been proven. You see the list of a number of them here. And a former NFL football player got in trouble and got a warning letter a short while ago for announcing on his social media page, promoting his particular product that CBD can prevent and cure the coronavirus. To date, there's no evidence of that. He took it down, but just like a number of other products that the FDA is chasing after as kind of quack cures for COVID-19, including products containing silver, that's a no-no in the FDA size. So let's talk very briefly before we get to Joe about lawsuits brought by private parties. There are really kind of four categories of lawsuits that some have been brought, some have been contemplated but haven't gotten very far. The first are claiming that products contain less CBD than labeled or advertised. So these are cases in which someone says, I bought a cream or I bought a drink or whatever that says it contains 600 milligrams of CBD. A plaintiff's lawyer sends it off to a testing laboratory. It comes back and says, well, it doesn't have more than 100 milligrams. And so the claim is, you shortchanged me. You said it would have a certain amount. You didn't have as much in there. I certainly wouldn't have purchased the product, or I wouldn't have paid as much if you had the correct amount. Those cases haven't gone as far as one would think so far, mostly because the leading case has been stayed under what is called the primary jurisdiction doctrine. We'll talk about that in just a moment, but it essentially means the court is going to defer to the scientific and rulemaking expertise of the FDA to determine whether certain amounts of CBD are more efficacious than others and whether they can be promoted for certain uses, et cetera. So that has stalled at least the first case to come to a court. There are several others that are pending in that category. Obviously, you can avoid that by making sure that your product contains what you say it contains. Second set of lawsuits are those involving that are claiming that CBD products are either ineffective, they don't work, or they hurt somebody. I haven't seen any cases yet that claims that anybody has been hurt by CBD. There have been claims that essentially challenge their efficacy, but a lot of these run into questions over proof, and so this is not a big area right now. Related to that are lawsuits claiming that products are deceptively labeled or advertised that they have a certain beneficial effect. So not only do the feds say that you can't market your product as a cure for mad cow disease, but private litigants say, well, I bought the product thinking that I would cure my arthritis or do this or that. It didn't have that effect, and claims like that might have some legs. And finally, there are suits of which there are many now claiming on the basis of an 11th Circuit opinion, we'll talk about in just a second, that because the FDA says that these products containing CBD are prohibited from being sold in interstate commerce, that the products are illegal and therefore have no value, and this both gives plaintiffs the standing to sue and to claim the entire value or the entire purchase price as the amount of damages per sale. That's an interesting proposition, and we'll see where that goes. So here are in just a minute or two before I turn this over to Joe, here are some of the issues that are presented in these cases. First, if the claim is simply that the product harmed a person or it didn't have the desired effect, it's going to be very hard to prove that. Somebody comes in and says, it was advertised as being a pain reliever. I didn't get any relief. That's going to vary from person to person. It's a little bit subjective, and particularly if you try to assert such a claim on a class basis, there are going to be really individual issues of proof that are going to make that a tough go on a class basis. Similarly, if the claim is, gee, I was deceived into buying this, I thought it would solve all these problems and it didn't, or I saw CBD and I thought it was a miracle cure. Again, depending upon what the label says, that's going to be tough to establish, particularly on a class basis. That said, if the label goes too far and makes some of the more extravagant claims, or if the advertising makes extravagant claims about what can be cured and how this is going to create a new you, those claims might have some legs. In a lot of these cases, one of the difficulties is, well, what are your damages? You paid a certain amount for the product, whether it's a cream or a food or an oil or whatever, and if it didn't work as expected because it didn't have as much CBD as you thought or whatever, what are your damages? If it had less or didn't have the claim, were you really not going to buy the product, et cetera? And typically what you have to show is kind of the benefit of the bargain theory of damages, which is the difference in the market value as the product was when you bought it versus what it should have been according to the label, which is hard to prove. But along comes this 11th Circuit opinion, de Bernardis versus IQ Formulations. This was not a CBD case, but it was a nutritional supplement case. And the nutritional supplement, it was supposed to be an energy stimulant. It contained dimethylbenzoathiolene, DMBA, and this is linked to cancer, and the FDA has said any supplement containing DMBA is adulterated. A class action was commenced in Florida on the grounds that you sold this particular energy stimulant. It contained DMBA. It was therefore illegal to sell, and that the purchasers had not been informed that they were purchasing an illegal product, and the entire class of purchasers should get their money back. That was challenged on standing grounds. The district court dismissed the case, saying that there was no demonstrated injury in fact. The 11th Circuit reversed and said, the FDA says that you can't sell this product. If it's prohibited from being sold, it is per se worthless, and therefore there is both standing and by implication that the measure of damages is the complete purchase price. Now, we don't know the end of that story, but at least those cases are going to survive a motion to dismiss. The question that's kind of out there that I hinted at earlier is, why should the court give the FDA such deference in its determination? The fact that the FDA issued a warning letter, which is usually the trigger for these lawsuits, is that in itself enough when the FDA, by its own definition, says warning letters are informal and preliminary and not a final position. So there's more to be written on that. There are also issues about preemption. There is no private right of action under the Food, Drug, and Cosmetic Act. And so merely bringing a suit claiming a violation of federal law is likely, at least in most states, to get bounced on the basis of preemption. In certain states, such as California, where the Food, Drug, and Cosmetic Act is incorporated into consumer protection statutes, that may be different. But the law does say that although you cannot look to FDA regulations or the Food, Drug, and Cosmetic Act as the basis of your claim, it can be used to show a misrepresentation. And finally, the primary jurisdiction doctrine, as I mentioned earlier, this is when courts are pointed to pending regulatory action by regulatory agencies. In this case, the FDA. The FDA has announced that it's looking into further regulation of cannabinoids in food and beverage products, as well as looking at them as potential treatments. And so the court essentially says we're going to stand down and wait for the FDA to rule. That works as long as the FDA is shown to work expeditiously. A couple of years from now, if we still don't have regulations, fewer courts are going to adopt the primary jurisdiction doctrine. Joe, I'm going to turn it over to you now for the federal criminal law quandary.
Oh, well, thank you, Chip, and thank you, Sativa. We're going to talk now about the banking quandary. And we've been giving advice to banks going back to 2013 when the federal government indicated we understand that states are now licensing marijuana for medical reasons, and maybe we want the payment of funds to purchase marijuana to be within the payment system as opposed to outside of it. And we've now gone down the road to the point where marijuana transactions, and I'm not talking about hemp here, I'm talking about THC-related transactions, are becoming mainstream commercial transactions, and that means financing. And the estimate is that within several years, it's going to be $25 billion a year within the United States and Canada. And that means that it's becoming an agribusiness, and we see almost on a daily basis that companies involved in cannabis are attempting to vertically integrate the various businesses, the various licenses and authorities, not only on a state-by-state basis, but some are trying to move on an interstate basis, which falls right in front of the doorstep of potential criminal activity. And you see here the pendulum, because banks are also looking for business, and banks are realizing that this is now happening, notwithstanding the federal government. And can you view the issues of federal criminal laws and cannabis from a risk management perspective, or do you look at it simply from a criminal perspective and decide you're not going to participate? Legal or not under state law, the cultivation, distribution, and sale of cannabis remains illegal under federal law. You cannot deal with cannabis, or as it's termed under the criminal side, marijuana. And if you help in any way the anti-money laundering laws in terms of moving the funds arising from prohibited drugs apply, and if you're a bank or another institution that's not directly involved, you can still become subject to criminal penalties and fines. There can be conspiracy liability and accessory after the facts liability. The Supreme Court of the United States and the U.S. Constitution have clearly indicated that federal criminal law applies regardless of whether state law is silent and whether or not it specifically permits the activity, such as dealing with cannabis on a state-by-state basis. And the fact that you're doing it on an intrastate basis is an irrelevancy. However, in those situations, some folks that are involved in the cannabis business believe that if you keep your activities confined to a specific state, it may diminish the intent to violate law. Now, just as very, very quick background here, all of this arose when the Cole Memo was appeared in 2013 under the Obama administration, and it indicated that, yes, indeed, we would like to bring sales of marijuana into the payment system for the banks. And unfortunately, when the new Attorney General came in after Trump, former Attorney General Sessions, he just hates marijuana, and he rescinded the Cole Memorandum. The Cole Memorandum itself does things that you would probably think that bad guys do when you're dealing with drugs. You can't distribute it. You can't take money from it. You can't grow it on federal grounds. You can't give it to minors, all the things that you can probably make up your own list and decide is the case. The shorthand version, though, that anything Tony Soprano would probably approve of violates the Cole Memo. But if you're not violating the Cole Memo, well, there was an encouragement on the part under the Cole Memo saying that we are not going to prosecute you. And then we turn over to the money laundering side, which is FinCEN, where FinCEN realized, wait a minute, it's still a federal crime, and so we do want you to bank marijuana companies, and they came up with their guidance indicating that as long as you do this properly and comply with the anti-money laundering laws as well, you will be fine. And the red flags that we were talking about a moment ago that were in the Cole Memo, well, they expanded them to 22. And they also created, for those of you who are anti-money laundering aficionados, they created 3 new types of suspicious activity reports, or SARs. And the first was that if you're dealing with a marijuana business, you file with, as a SAR, a marijuana limited SAR saying, hey, we're doing this, here's who we're doing it with, but these guys are doing it properly under state laws. Then you end up where you realize, well, wait a minute, something's going wrong here, and so you file another SAR indicating that, well, we're not quite sure whether or not it's criminal activity. Maybe it's not Tony Soprano, but they haven't maintained their licenses or something's gone amiss, and we want to raise our hand and say, wait a minute, you need to take a look at this. There may be a problem. And then finally, if you realize that Tony Soprano is actually involved in it and they're moving bricks of marijuana across state lines, you file a marijuana termination notice saying we've gotten rid of these guys, we have fired them, they no longer have an account at the institution. And by the way, under the money laundering laws, you can call up your neighborhood bank that you're in competition with and say, if Tony Soprano decides to come in because we just fired him from our bank, don't do business with him because he is a bad guy. And again, here you see the due diligence requirements that FinCEN laid down. But here's something that has always been difficult here when a bank has decided they want to deal with marijuana, and that is FinCEN has indicated that if there's ongoing activity, you have to update the SARs every 90 days. So that means you've got to file an updated SARs every 4 times a year, and you have to do due diligence to see whether or not they're still involved in the activity, and you've got to update it, which means that there's really an expense and there's really some due diligence that banks are not really well positioned to do on an ongoing basis with customers. Now, I mentioned that the Cole Memo has been rescinded, but FinCEN said they still follow it, and they want you to follow it. But they also said that when you read the Cole Memo and also the FinCEN guidance, it deals with people that are directly touching the plant. So that would be cultivating it, transporting it, processing it, or selling it, but not folks who are indirectly involved in cannabis activities. And the banks have picked up on this concept of a Tier 1 company or entity, meaning you're touching the plant. Tier 2, you're related to it, but your revenue is primarily related to it, such as, say, a company that is a holding company that owns marijuana companies that are touching the plant. And then you got everyone else. And in California, that includes just about everyone else because it's become such a large part of the economy. What I do want to spend some time on, and in the next couple of minutes, is this is becoming traditional commercial activities, and banks are now not only looking at the deposit side of it, because small banks need the deposits, but medium and larger banks are now looking at the opportunity to finance cannabis activities. And there's a laundry list of things that folks need to take a look at, which are a little bit different from normal underwriting. Just going through a few of them quickly, and these are things that banks are now asking and other lenders are asking when they're thinking about financing. In terms of underwriting, there's a cannabis revenue analysis. What is your revenue? How is it coming? Is it mostly from cannabis? And there's a tax code issue that says that you cannot deduct from your federal taxes revenues relating to the sale of a federally banned drug. On the case of banks, there's concentration issues because what has actually occurred in the case of smaller banks in rural areas, they've been very successful in terms of banking marijuana companies, but federal banking regulators do not want you to have all your eggs in one basket. And so the issue is you may have to go somewhere else, or we have to find a way to getting some of these marijuana deposits off of our books. There's real significant loan documentation issues which arise in terms of the reps and warranties that a marijuana company needs to give, including an agreement to allow the bank to be able to engage in the 90-day due diligence that I mentioned. Where it also becomes really difficult is analyzing the fact that if you're dealing with marijuana, you're probably going to be asking for security interests, both in personal property and in real property. And depending upon the state law, you probably do not want to foreclose on a marijuana crop or on marijuana itself that's been processed. How do you go about doing that? Real significant issues which have to be just worked through very, very carefully. And what we haven't had a chance to talk about, but Sativa mentioned, is cannabis in the COVID-19 environment. What is happening there, it is happening everywhere else, is that they're having real serious cash flow issues. There's now downturns in the economy in certain parts of the country, and you've got bankruptcy issues and insolvency issues. The overwhelming trend in regard to marijuana is that you cannot make use of the bankruptcy code in order to be able to resolve an insolvency. You have to go into state court and use state receivership laws. And again, depending upon the state receivers may not want to take possession of marijuana. The federal banking regulators, have been actually taking a very realistic approach, which is the risk management approach. Do you have policies and procedures? Do you know what you're doing? And that's been really helpful. Just another quick point, and that is what has been ignored throughout this entire process. If you're doing something legally, not illegally, but legally, the movement of funds both on an international and on a interstate basis, really problematic. There's been no enforcement, and yet those things are out there, and some of the protections we mentioned a moment ago arguably don't apply. Other things to be looking at, insurance issues, profitability issues, employment issues, whether or not you can somebody can come into your place of business stoned, and the answer is probably they cannot do that. In terms of large Wall Street type financings, the need of legal opinions, again, issues which come up all the time. And finally, I want to end up by indicating that the best way of addressing all of these things is what we consider to be the gold standard, and that is the U.S. Sentencing Commission's guidelines for effective compliance and ethics programs for corporate offenders. And there's 7 different components of this, and for banks that we have worked with that have indicated they want to dip their toes into the cannabis waters, there's ways of being able to structure an effective compliance program, and what that does, it really diminishes the intent to violate laws. You can see them here. They are certainly complicated. They involved due diligence. They involve the involvement of the board. They involve a bank-wide component to be doing this properly. But that is the way that you really can address this in a manner if you determine that, yes, we want to be involved, and what degree you want to, whether it's going to be a first-tier, second-tier, or third-tier company involved in cannabis, is something which, again, requires a lot of internal discussion and certainly comments at the board level. We are now just about at the end, and that is a very quick review, and I'm going to turn it back over to Chip.
Well, thank you, Joe, and thank you, everyone, for participating. As Joe mentioned, we're at the end of our hour. We will stick around for a little bit if people have questions, if you want to text those in. Otherwise, we have our contact information, which I'll pull up on the screen. You see it now. Feel free to follow up by phone or by email with any one of us, and we're happy to answer your questions. Hold on. We do have a question here. The FDA's most recent statement singled out potential full-spectrum hemp extract versus CBD isolate used in the Epidiolex drug as potential guidelines. Also seem favorable for dietary supplements versus food and beverage. Sativa, do you want to comment on that?
Yeah, so thank you for that question, Scott. That's actually a very good point to make, which is up until this point there had been a lot of speculation within the industry as to whether or not it was really appropriate for the IND preclusion rule, which is really the basis for not allowing CBD in food products and dietary supplements, whether that was appropriately applied to CBD. And that was based on this notion that the article that was approved in Epidiolex was, as you noted, a CBD isolate. So it was a pure form of CBD that did not contain any other cannabinoids. And folks within the industry were saying, well, that could and should be deemed a different article than something like a full spectrum hemp extract, which contains not only CBD, but all of the other various cannabinoids within the cannabis plant. And so the notion there was just simply that what was approved in Epidiolex is not necessarily the same thing that's being used in these products. And so some of these products may not appropriately fall within the scope of the IND preclusion rule. The FDA had been primarily very silent on this point up until their most recent guidance, which was, as you noted, the very first time that they really called out a differentiation between full spectrum hemp versus CBD isolate and the possibility that they may interpret those to be different articles moving forward as they develop this path forward for CBD products.
Yeah, excellent question. Thanks for that. If anyone else has any questions, you can type it into the chat box. Otherwise, we invite your questions. You've got our contact information up here, and we'd be pleased to speak with you. Thank you very much, everyone, for attending.
Absolutely. Thank you all.